Warning: the following video contains explicit language which may be offensive to some viewers or inappropriate for children. The content within this video is intended for mature audiences only.
Some updated information here on what's going on with Abrego Garcia's situation.
Buckle up, everybody. It's going to be 2 weeks of intensive discovery as ordered by Judge Zinnes. In fact, she used the phrase, buckle up, to the Department of Justice's lawyer, Drew Ensign, today in the Abrego Armando Garcia hearing. She's still trying to figure out whether contempt is appropriate, but in the meantime, to support that motion for contempt for their failure to abide by the 9-0 ruling of the United States Supreme Court to facilitate the removal from an El Salvadoran jail, Armando Abrego Garcia, the judge has ordered now, coming off of a hearing late today on Tuesday, the intensive discovery that she wagged her finger at Drew Ensign with during a very heated discussion during today's hearing. I'm Michael Popak. You're on the Midas Touch Network and Legal AF. Let's get to it. Last Thursday, the United States Supreme Court ruled and affirmed Judge Zinnes' order and said that everything about her order related to the facilitation requirement, that the government facilitate Armando Abrego Garcia's removal and release from a El Salvadorian jail, was proper, constitutional, and they affirmed it. They also said that everything she said about due process and constitutional rights as the requirement for the injunction are upheld. 9-0. It's all over. It's all over. Now it's just about what is the remedy for this illegal act by the government. The government has dug in and said, no, we don't agree with the Supreme Court's ruling. We don't agree with the language about facilitate. We think facilitate this is like a spelling bee. The government literally does not know what the word facilitate means. They've twisted it so out of proportion and contorted it. They want it to read that the Supreme Court affirmed that they only had to facilitate on the domestic side if he just accidentally showed up, Mr. Garcia, at a port or at an airport, like he did his own prison break and just wandered in, that they would let him in. That's what they think facilitate is. But now they're doubling down after the White House press conference on Monday, and they're saying even if he were to present himself, they would let him in, but then deport and remove him to another country and revoke his status. That's in a brand new filing just before this hearing. I got two pieces of paper in front of me. I got a hot off the presses order of discovery by the judge, which is a prelude to a contempt finding, and a new filing by Mr. Mazzara, the acting general counsel of Homeland Security, in which he now says in paragraph 9, and this came up during the hearing and not in a good way for the Trump administration, I have been authorized to represent that if Abrego Garcia does present at a port of entry, like he just wanders in from El Salvador from a supermax prison, he would become subject to detention by DHS. Yeah, we get that. In that case, Department of Homeland Security would take him into custody in the U.S. and either remove him to a third country or terminate his withholding of removal because of his membership in MS-13, and as opposed to El Salvador. Okay. Now, the other problem the judge had today, before we get into the buckle up comment from the reporting within the room, is that they tried to file just before the hearing at 4 o'clock a unofficial transcript of the Bukele of El Salvador, the petty dictator of El Salvador, the guy with the black T-shirt and the suit jacket, like all petty dictators, when he was shoved into that room for a pitch and catch, a scripted call and response between him and Donald Trump so they could use it in the courtroom, when he said, why would I smuggle a terrorist back into the United States? I will not do that. In fact, we have the clip. Let me show you the clip because I came up in court today. Let's roll the clip one more time.
How can I smuggle a terrorist into the United States? I don't have the power to return him to the United States.
So you can release him inside El Salvador?
Yeah, but I'm not releasing, we're not very fond of releasing terrorists into our country. We just turned the murder capital of the world into the safest country of the Western Hemisphere, and you want us to go back into the releasing criminals so we can go back to being the murder capital of the world? No, that's not going to happen.
Well, they'd love to have a criminal,
yeah, there's a fascination.
They would love it.
Yeah.
Back to me, sorry. Drew Ensign, the lawyer who's arguing it, says, see, Judge, here's the official transcript. Here's, is it? And the judge says, that's not evidence. We're going to do this by the federal rules of civil procedure. I want sworn affidavits and declaration. Don't hand me some sort of transcript as a substitute for evidence. And I don't like the fact that I'm not being told what steps have been taken to get him out. Apparently, this is the judge now today at the hearing. No steps have been taken. I'm going to read to you from her order. No steps have been taken at all in violation of my order. In other words, she is just walking them into the trap. Just walking them into the trap. Let me read to you from some notes from people that were in the room today. When Drew Ensign pointed to the transcript, I got an unofficial transcript of the meeting with President Bukele now. The judge said, first of all, you point to that, but we're doing this by the book, by the federal rules of civil procedure. She then went on to say, we're doing intensive 2-week discovery. I'm going to set a discovery order. The other side, Mr. Abrego Garcia's lawyers are going to get interrogatories, questions under oath that have to be answered. They're going to get at least 3, if not more, depositions, all within the next couple of weeks. And if they need more, I'm going to give them more in support of their motion for contempt. She said, and I quote, I'll remind everyone here that there are no business hours. It will be 2 weeks of intense discovery. Once we have a record, take it from there, right? Oh, and we'll take it from there. In other words, no PTO, no personal time off, and drop and give me constitutional compliance. When Drew Ensign started to argue about the Supreme Court decision, she said, they affirmed me in every way, shape, and form. We're only talking about a remedy now, and I'm not going to let you to relitigate. She said, if I made a finding of contempt, it'll be based on the record before me, and I don't consider this transcript given to me 15 minutes ago to be sufficient. The question is, she said to Drew Ensign, what have you done to facilitate his release, and what to ensure that this case is handled as it would have been had he not been sent to El Salvador? She also reminded him that he's getting it wrong on the word facilitate, that the government routinely requests return of people wrongly removed, but there's no evidence that that had been done here. So she rejected entirely all of the decisions, all of the positions that Drew Ensign for the government took about what the words in the 2-paragraph Supreme Court ruling means. Let me read to you from her order, which came off of the hearing transcript. Because when you hear these findings, you know that the Trump administration is about a minute before midnight getting nailed with a contempt finding. So here's what she says. This is on page 2 of her order. It is undisputed that Abrego Garcia is entitled to injunctive relief for the reasons previously discussed and affirmed by the Supreme Court without exception. And she said later in the hearing, every day that Mr. Abrego Garcia remains in that notorious Supermax prison is another day of irreparable harm. As to the scope of such relief, she continued, the Supreme Court of the United States unanimously affirmed that the district court, her order, properly requires the government to facilitate Abrego Garcia's release from custody. Not if he wanders around and shows up at a port or on a boat or at an airport, released from custody in El Salvador, and to ensure that his case is handled as it would have been had it not been improperly sent to him, El Salvador. To that end, the Supreme Court forewarned that the government should be prepared to share to the judge what it can concerning the steps it has taken and the prospect of further steps. She then continues, this court in turn ordered no more than what the Supreme Court endorsed, that defendants take all available steps to facilitate the return of Abrego Garcia to the United States as soon as possible. because bound within this remedy is Abrego Garcia's release from custody and the insurance that Abrego Garcia's case is handled as it would have been had he not been improperly sent to El Salvador. To advance that remedy, the court required swift disclosure of that which stems most obviously from the Supreme Court's affirmance: the current physical location and custodial status of him, what steps, if any, the defendants have taken to facilitate his immediate return to the U.S., what additional steps they will take. This information is wholly consistent with ascertaining what, if anything, defendants have done to facilitate Abrego Garcia's release from custody in El Salvador. Notably, she then goes on to what facilitate means. Facilitate means to make the occurrence of something easier, to render less difficult, quoting Merriam-Webster's dictionary. Instead, she says the defendants obliquely suggest that facilitate is limited to taking all available steps to remove any domestic obstacles that would otherwise impede the alien's ability to return. The fallacy in the defendant's argument is twofold. First, in the immigration context, as it were, facilitating return of those wrongfully deported has and always has included more extensive governmental efforts endorsed in prior precedent. Second, and more fundamentally, she ruled, defendants appeared to have done nothing to aid in Abrego Garcia's release from custody and return to the United States. Based on that, she's ordering discovery. Now, some people might think, why didn't she find him in contempt? We're getting there. You got to make a record. The record's got to be airtight. The way that a federal judge does that, or a state court judge, is allows discovery. That's the gleaning of facts in an adversarial process through depositions, questions under oath in person, through on paper questions under oath, interrogatories, through requests for production. Then when she gets that record together, she'll do an evidentiary hearing in a week or two, or after the discovery is completed in the next 2 weeks. In the third week, she'll hold a hearing for contempt. And then she can make her ruling. We watched something similar with Judge Boasberg about the Alien Enemies Act. He just never got to the point of contempt hearing because the Supreme Court divested him of jurisdiction and sent the case off to individual judges in Texas. I don't see that happening here, given the Supreme Court ruling fully in favor of Judge Zinnes. Now, here's what she's ruled. By no later than Wednesday, April 16th, that's tomorrow, at 5 p.m., plaintiffs may create 15 interrogatories and 15 requests for production, 15 categories of documents sought, 15 questions under oath, and the defendant shall serve their response by Monday, a week from yesterday. Plaintiffs may also, by no later than Wednesday at 5 p.m., notice the depositions, right? Set the depositions for all the people that filed these screwy declarations in front of her that were violative of her order. That would be Robert Cerna, Michael Kozak, and this guy, Joe Mazzara, the general counsel of the Homeland Securities. And those depositions will get taken a week from tomorrow as a deadline. If no later than Wednesday, also by a week from Wednesday, the 23rd of April, plaintiffs may move to conduct 2 more depositions because they may pick up names from the people that they're deposing. That's why the judge said at the top of this hearing, buckle up, intensive discovery. I don't believe your argument. I don't believe your argument about what facilitate means. And every day you file something, I'm not relieving you of your obligation for 5 p.m. filings every day. Every day is basically, in her mind, is another version of contempt, another act of contempt, but she needs to develop this record. Once the conclusion of the expedited discovery happens, she set an outer boundary of Monday, April 28th. So 2 weeks from now, the plaintiff shall then supplement their motion for relief. Remember, the plaintiffs already filed a motion for contempt. She's asking them, once you get all the discovery in the record, to supplement it with whatever you get out of these people on the Trump side and bring it back to me. And then gave the Trump side until Wednesday, April 30th to respond. Once the court has all of that, then the court will hold a hearing. In the meantime, the court will hold in abeyance, will sit on for a moment the other remaining requests that the plaintiff made, find them in contempt, amend her order to give them specific instructions. She's going to wait until expedited discovery and supplemental briefing is done. That said, she ends the order this way. Should defendants, the Trump administration, fail or refuse to engage in the above described discovery in good faith, plaintiffs are free to seek separate sanctions on an expedited basis. Drop down and give me constitutional compliance. This is Drill Sergeant Zinnis. That's every federal judge I've ever been in front of. And I'm glad to see she's remained in this case trying to administer justice. I'm going to continue to follow it right here on the Midas Touch Network on Illegal AF. You can see there's a lot to update. I am sure Donald Trump's not going to be happy with this. It's going to be very hard for him, however, to take an appeal, emergency or otherwise, to the Fourth Circuit Court of Appeals or to the United States Supreme Court. They are not, at this moment, going to get in the way of expedited discovery related to contempt, while a judge uses her inherent authority to manage her cases and manage her docket. So I'm managing expectations here. I'm not worried about a Fourth Circuit application by Donald Trump or a short circuit to the United States Supreme Court. And you shouldn't either. Stay here on the Midas Touch Network. Hit the free subscribe button. Come over to Legal AF. Hit the subscribe button to that YouTube channel as we continue our march towards justice. I'm Michael Popak. You're on the Midas Touch.